Okay, we've got a good crowd already loaded. We're going to go ahead and get started, and I know folks will be joining us as well. Thank you for joining us for a joint event with the Metroplex Democratic Lawyers Association. Adam Yost has done a great job of putting together a panel, and it's a really great opportunity for those of y'all in the Metroplex area to get engaged on the ground floor of what's been working really well in Harris County and now statewide with the Democratic Lawyers Association. Obviously, we're engaged in voter protection efforts, but there's a lot of other opportunities for engagement with the judiciary, with local party that they need our help. And building on the base that we've been able to build in Harris County, we look forward to having chapters across the state and statewide under Barber Radnofsky's building something that will make a difference, not just to the law practice, but to Texans and Democrats across the state. I also want to remind you that next week on the 29th, which was scheduled for our Clarence Darrow Awards hybrid event at Zaza, given the circumstances and not wanting to have a Rose Garden event of our own, we've gone ahead and pushed that to the spring, hopefully. But we will have an event with Dean Bledsoe and 4 of our hopefully newest judges, a chance to meet them, folks that are non-incumbent, and that'll be set at 6:30 on the 29th. And as with our other events that we've done since the pandemic, it's open to all, not just members. It's free. I think it'll be an interesting and engaging event. Adam Yost is a lawyer who has joined us in Texas and has been integral in getting the Democratic lawyers off the ground in the Metroplex. He's the one that's put together this outstanding panel. And I want to go ahead and turn it over to him for this event moderated by Barber Radnofsky. Thank you, Adam.
Thank you, Mike. I don't want to take up a lot of your time. I know that you're all excited to hear what our great panelists have to say, but if you give me a couple minutes just to make a plug for the TDLA and the DFW chapter, I'd appreciate it. Like Mike said, my name is Adam Yost. I'm the co-chair of the Dallas-Fort Worth chapter of the Texas Democratic Lawyers Association. Our other co-chair, Brandon Maxey, is on. And together what we are is the local arm of the TDLA, which is the Democratic Party's Lawyers Group. And part of what we do is put on events like this that we think are going to be of interest to lawyers in the legal community. But beyond that, it's also a way to organize lawyers, Democratic lawyers across Texas, and hopefully be able to use our talent and our training to help protect the right to vote and help elect more Democrats to office. And, that's been, important for a long time, but it's especially important right now. I mean, we've all, I think, seen the incredible turnout that that's happened in Texas and nationally, but also the efforts that Republicans around the country have gone to try and prevent people from voting. And the TDLA is playing an active role in that in Texas through voter protection and on a voter hotline to help make sure that voters can vote. And so what I would ask and hope is that all of you can join us, whether that's on election day or after, to help, make sure that we can elect more Democrats and make sure that Democrats can make their voices heard. So I will put the link to to our group in the chat right now, and if anyone wants to sign up, that's where you go. And other than that, let me just introduce our panelist, or our moderator, Barber Radnofsky, who will go through and talk about all of our great panelists. And so Barbara is the president of TDLA and is really been integral in getting this all set up. And I apologize, I lost my my introduction, but Barbara is prolific. In addition to being the TDLA president, she's an author, an attorney, and a political candidate herself. She was a practicing attorney for many years and is now an active mediator. She wrote The Citizen's Guide to Impeachment and was the first woman in Texas history to run as a Democratic nominee for U.S. Senate in 2006, and then ran for Attorney General in 2010, and is just really done a wonderful job shepherding TDLA through its first year. And without any further ado, I'll turn it over to Barbara.
Thank you so much. Y'all are going to hear a lot more from Adam, who's come here from Virginia and is taking democratic politics already by storm in DFW. At any one time, there are hundreds of our members now throughout the state volunteering to protect the ballot. And we are not going to stop with this election. We intend to be a vibrant organization, and the folks here that are watching and the folks who've signed up through the link are much appreciated. I want to introduce the two speakers that Adam was able to get us. It's an ideal panel. First, let me introduce Katie Barber. Ms. Barber clerked for Justice Ginsburg during October term 2018. She previously clerked for Judge John B. Owens of the U.S. Court of Appeals for the Ninth Circuit and Judge Leonie M. Brinkema of the U.S. District Court for the Eastern District of Virginia. Ms. Barber earned her law degree from the University of Virginia, where she served as notes editor on the managing board of the Virginia Law Review, and she was honored as a member of the Raven Society and Order of the Coif. Ms. Barber practices in Richmond, where she focuses on high-stakes litigation, dispositive motions, and appellate advocacy. We have also the honor of a UT law professor, Elizabeth Sepper. She's at UT Austin at law school and a nationally recognized scholar of health law, equality, and religious liberty. She's written extensively on conscientious refusals to provide reproductive and end-of-life health care, and on the conflicts over religion and anti-discrimination law. Professor Sepper received her BA in history from Boston University and her LLM and JD from New York University School of Law. Following law school, she clerked for the Honorable Marjorie Rendell of the U.S. Court of Appeals for the Third Circuit and practiced human rights law with a focus on women's rights. What we're going to do for the first part of the presentation is ask Ms. Barber, who's agreed to get us started with a 10-minute overview with her perspective from working so very recently for Justice Ginsburg in 2018. And then Professor Sepper is going to speak to the impact of Justice Ginsburg, focusing on three categories: religion, reproductive health, and the role of women in the legal profession. Then we're going to briefly talk about two books, it won't take long, that we've actually had book events for in the past, and then give kind of a back and forth on the themes just for a few minutes. And then, because several folks have already stepped forward with questions, we're going to turn the matter over to Adam so that he can both curate the questions that we hope you guys put in chat. So start putting your questions in chat now, because Adam will be reading them and curating them for the last part of this presentation. And the folks who've already contacted us and have stepped forward, Adam will be calling on at the end as well to ask their own questions. So with that, let me ask Ms. Barber to get us off to a start for an overview about what it's like. You were with Ruth Bader Ginsburg. Tell us.
Thank you, Barbara, and thank you for that introduction. And thank you, everyone, for having me today. I greatly appreciate the opportunity to be with you all today and to honor the Justice's legacy. As Barbara said, I was fortunate enough to serve as a law clerk for Justice Ginsburg during the October 2018 term, which, as it turns out, was her second to last full term on the court. And it already feels like it was a long time ago for me, but really I've only been done with the clerkship for about a year. And so I think for that reason, I'm still really processing and will be for years to come everything that I learned from the Justice and everything that my year working for her meant for me, both personally and professionally. I think today, as we are here to discuss the Justice's legacy, there's kind of one overarching lesson that I have taken from her, and one legacy I think I will carry with me that has especially stood out in recent weeks. And that is what I think of as the Justice's fundamentally optimistic ability to take the long view of things and to persist and endure. And I was thinking about this especially because of a poem that Justice Ginsburg's judicial assistant sent to us, the Clerk family, the other week. And it was an excerpt of the poem "Death is Nothing at All" by Henry Scott Holland, which the justice used to send to friends of hers who were experiencing a loss, as we are now experiencing her loss. And there was one line in that poem that really stood out to me, and it's that life's significance is all that it has always been. The seams have not been broken, the thread has not been cut. And that line jumped out at me because I think it embodies so much of the justice's approach to her work and to her life. And that approach was a fundamentally hopeful one, and one in which the justice always took the long-term view of things and the larger perspective. And I think that helped her to continue kind of fighting the good fight for so many years. And it was a view that even in dark moments and difficult times, whether big or small, that we go on, we continue doing the work. We take care of what needs to be done today, and then we look forward to what there is for us to do tomorrow. And we believe that, you know, even if there's a setback today, there is still more to be gained and to be achieved tomorrow and the next day and on. And the justice would really kind of embody this for us on a daily basis. Whenever we clerks would meet with her to talk about that day's oral argument or the Friday conference that the justices had to discuss cases, we would meet and we would talk through the details of every case that had been argued and what needed, you know, what questions the justice had and what everyone had said, and try to wrap up where we were on those cases. And then the justice would say in her characteristically very methodical, spaced out speech, he would say, and so we go on to tomorrow, or we go on to next week, or to the next sitting. And there was always this sense of kind of, okay, we've done what we needed to do today, and now we've got to move on to the next thing. There's more work to be done. Let's move on to the next. And I think we as clerks always felt like, especially because the justice fell ill during our clerkship year, and we saw her kind of fight through that and endure that, you know, we really felt like she was just going to keep going on to the next for forever. At least that's really what we hoped. And with the justice's loss and with everything that's going on in our country and our world right now, I think there is so much that can feel, you know, dark and difficult. And what I take from the justice is this lesson of the justice, though, is that you know, with this fundamentally hopeful, optimistic view that we have a long road to travel, there's much work to be done, but nothing is irretrievably lost. There is still so much to gain, and we go on to the next. And so I kind of wanted to start by just offering to you all that kind of message of, I think, optimism and perseverance, and that was really kind of an overarching lesson that I really took from my year with the justice.
Thank you so much. Elizabeth, can we get your more legal perspective on things in as professorial as you'd like, so we can get an overview, and then we'll get more deeply into some of the questions y'all have raised or talked about.
Sure. Thank you all for having me. Thanks to Barbara and Katie, and for all of you, many of you, I can tell, who are on the call taking lunch with us. I should add that I am speaking only in my personal capacity, not in my institutional capacity. And I want to sort of situate the legacy of RBG in two of the areas that I know best, religion and reproduction, also with an eye to her contribution to women in the legal profession. And Barbara's comment about my professorial style did make me think, you know, when RBG was in law school, no professors looked like me. Even when I was in law school not so long ago, women law professors were not common, and they unfortunately remain a real minority in the in law schools, University of Texas in particular. You can look at our roster and see how few people are women on the faculty. And that's something that is changing, but should have changed earlier. So I want to situate RBG in this work. You know, her work in the area of reproduction and religion and probably beyond, I'd say, is really defined by what I see as a commitment to equal standing and respect in a democratic society so that everyone can participate and stand on the same ground. And in her work throughout her life and as a justice, she really drew on her own experiences of discrimination, of growing up in Brooklyn and seeing no Jews signs in New York State, of being one of the very few women who went to law school in the time period or became high-powered lawyers or ultimately justices. And her cultural cachet, right, the notorious RBG, isn't due to her flashy personality or her attention-seeking behavior. She was not Justice Scalia, but it was due to her principled commitment to get the law right and her remarkable hard work and determination. And that's what she's really known for, is just being a workhorse. It's sort of incredible hours and effort. So I want to focus on just a couple cases that I think combine the themes of religion, reproduction, and women's participation in the workforce. And one of these is not particularly well known, Struck versus Secretary of Defense. In 1972, Ruth Bader Ginsburg, when she was a lawyer for the ACLU, took the case of Captain Susan Struck to the Supreme Court. Captain Struck was pregnant. She was a practicing and devoted Catholic, and she refused for religious reasons to get an abortion. But her continued pregnancy and refusal to get an abortion meant an automatic discharge from the Air Force. This was common to all the branches of the military and also common in private workforces as well. Now, for RBG, this regulation of pregnancy denied equal protection to Captain Struck and to other women. And it did so because it enforced sex roles that meant pregnancy disqualified women for wage labor, and that women were meant for the role of mothers while men were meant to be breadwinners, to go out into the workplace, to serve in the military. And for her, and it's always interesting to think about how with just one little change or shift, where would we be? What would have happened? For her, Captain Struck's case should have been the Supreme Court's first reproductive choice case, that is raising the issue of a right to terminate or to continue a pregnancy. And to her mind and the mind of the modern reproductive justice movement, these two are inseparable. Both are necessary for women's equality in the workplace and in public life. But Ginsburg also emphasized that Struck's free exercise of religion was at stake. The Air Force was forcing her to either leave her job or to violate her conscience. Now, it didn't end up being decided by the Supreme Court because the government abandoned the policy and mooted the case. But her brief really stood out for linking pregnancy discrimination and sex discrimination and connecting restrictions on contraception and abortion to sex discrimination at work. Now, at the time, courts, of course, had very little understanding of sex discrimination. The Supreme Court had decided its first sex discrimination, for the first case in which it found sex discrimination just the year prior, also brought by Ruth Bader Ginsburg. And just a year after this case was mooted, the Supreme Court famously opined that discrimination against pregnant women was not sex discrimination. It was just distinguishing between, you know, pregnant people and non-pregnant people. And to this day, I'd say the justices, as well as many lower courts, have a hard time connecting reproduction and equal protection. But Justice Ginsburg's perspective has made significant strides in legislative bodies, and this is part of the democratic nature of her work. We have the Pregnancy Discrimination Act. We have new state protections recently enacted to bar employers from discriminating against workers for their reproductive decisions, whether to parent or not, to terminate a pregnancy or to carry to term. And we have state contraceptive mandates and the like. We have determinations that pregnancy discrimination encompasses discrimination against those who make a variety of reproductive choices. Now, turning a little more squarely to reproduction in the court's abortion jurisprudence, Justice Ginsburg joined the court, and again, a question of timing and how things might have changed. She joined the court a year after Planned Parenthood v. Casey was decided, where the court both reaffirmed Roe v. Wade, but also significantly watered it down. And Casey invited legislatures to protect women from their own decisions, engaging in increasingly aggressive campaigns to dissuade them from having abortions. And it also suggested that abortion decisions can cause negative mental health consequences for women. So in the face of this shift in the doctrines around reproductive decision-making, Justice Ginsburg stood as a significant counterweight to attempts to continue the project of rewriting facts about abortion. One of her powers was pulling the curtain aside and exposing what was really going on, both at the court and with regard to anti-choice efforts. For example, when the Carhart v. Gonzalez case came to the court, this was known as the partial birth abortion case. It essentially banned a fairly common abortion procedure and contained that's used in later abortions, and it contained no exception for women's health. And this is really the first time that the court was willing to allow states to regulate without that exception for women's health. And she repeatedly reminded her colleagues and the rest of us, and this is a quote, legal challenges to undue restrictions on abortion procedures do not seek to vindicate some generalized notion of privacy. Rather, they center on a woman's autonomy to determine her life's course and thus to enjoy equal citizenship stature. So for her, liberty and equality were inevitably linked here when we're talking about reproduction. And she reminded her colleagues that they had actually signed on to that perspective in the abortion jurisprudence that predated Carhart. And what she also did in a very valuable and characteristic way is go through the facts, right? Explain to readers what it is that was at stake when there was no exception for women's health at the end of life. And she also, again, pulled back the curtain on the court. She said to the majority that they were upholding a, quote, flimsy and transparent justification for a ban without any evidence that, as Justice Kennedy wrote, women suffer from severe depression and loss of self-esteem from the decision. Because in the parlance of today, Justice Ginsburg, if she did anything, she trusted women. And so that was part of her insistence with the court to tell the truth about what was going on the ground and also to give them a sense of the experience of women. She was actually the only woman on the court at the time Carhart was decided. Now, Justice Ginsburg is sometimes described, and just was in the New York Times a few weeks ago, as the most secular justice on this, frankly, increasingly reactionary court. And by secular, of course, meaning in her jurisprudence, not in her personal commitments. But in my view, she was really deeply committed to religious accommodation, sensitive to religious minorities, and really aware of the power dynamics of religious institutions and workers and consumers. And from the time of Struck, right, during her years as a litigator, we see her showcase that kind of sensitivity. And recent cases really highlight that. So in Hobby Lobby, for example, the famous corporate religion case where for the first time a for-profit corporation was allowed to exercise religion and to gain an exemption from the contraceptive mandate that made insurance that their employees earned more valuable. And Justice Alito, who wrote for the majority of the court, concluded that the cost to women from the accommodation would be zero. And that's where Justice Ginsburg really came in. She argued that the court had radically rewritten religious liberty jurisprudence to give favors to powerful corporations over their workers. And Justice Alito had erased women from his opinion. So she brought them back. And that opinion is just a testament to her skill in describing and understanding the real life conditions under which women labor in low-paying jobs and how economic justice connects to reproductive autonomy. And so she accused her colleagues of underestimating, if not ignoring, the burdens that they had placed on women workers. She pointed out that before the Affordable Care Act, women were paying 68% more in out-of-pocket health costs. And while the cost of a year of contraception or the cost of an IUD might seem small to the elite members of the Supreme Court, it was anything but that to women who were working in the kinds of jobs at stake in the Hobby Lobby stores. And she wasn't insensitive to religious conviction. In fact, she feared that if you allow employers and religious institutions to impose their own beliefs and policies that they put onto workers, then women and their partners will lack the ability to live out their own religious and moral convictions about parenting and reproduction. So like Captain Struck many decades earlier, women workers or women dependents would have to choose employment and base it around their reproductive decisions. So Hobby Lobby alarmed Justice Ginsburg, and we could get into this more in Q&A, but there's lots of reasons to be alarmed about it. And in her final dissent, again with the contraceptive mandate coming back to the court, not for the first or second or third time, she wrote, accommodating claims of religious freedom, this court has taken a balanced approach, one that does not allow the religious beliefs of some to overwhelm the rights and interests of others who do not share those beliefs. Today, for the first time, the court casts totally aside countervailing rights and interests in its zeal to secure religious rights to the nth degree. And she pointed out again what it would mean to strip on the government's own admission, somewhere in the neighborhood of 70 to 127,000 women of their access to contraceptive coverage. Now, the last thing I want to note is that Justice Ginsburg saw women, and we saw her do that, even when, as she so often had to, she had to first proclaim, I dissent. So thank you, and I look forward to talking more.
Thank you very much. You know, your comments, particularly on Hobby Lobby, the footnotes alone would bear a wonderful lecture from you just on the footnotes and how I believe it may have caused Scalia to respond in maybe rewriting a bit at the beginning of Hobby Lobby. I wanted to ask, before we talk about books or anything, there's a question in the chat that I happened to sneak a look at that really gets to basics, which is, the differences between Scalia and Ginsburg. They did find agreement on opera, but I would be interested, and I can tell that the audience would be interested in both of y'all's reflections on this relationship between Scalia and Ginsburg and how they could go at each other and still be friends, and where they had common ground other than opera. Common ground other than opera is the question between Scalia and Ginsburg. And Katie or Liz, jump in.
I can start on that. Speaking from, I was not clerking at the court when Justice Scalia was still on the court. And I actually, since the justice's passing, have grown increasingly, nothing personal against the asker of this question, but the focus on the Scalia-Ginsburg relationship kind of frustrates me, because I honestly don't think there's anything that remarkable about the justice being appointed for a lifetime term with another colleague also appointed for a lifetime term and them being friends. The justice was that way with everyone that she worked with on the court. And so I think the focus on how could these two such different people be friends with each other. I mean, they worked together on a daily, weekly basis. They knew each other. When you're one of the 9 justices, you're in a small, rarefied environment where you are one of only 9 people who knows what that experience is like. And so I don't think there's anything that remarkable about a woman being friends with a male colleague that she also has to work with for the rest of her career. And then it's especially unremarkable, I think, in the context of the Supreme Court. But I will say, I do think that the justice had a really genuine care for really all of the justices that she served with, and that it's really a family of people at the court. And I think once they are all there together on the court, they all value that institution kind of above and beyond their individual whatever, and they value it above to kind of like whether they are having differences in a particular case or something like that. They value kind of the long-term institutional health of the court. And as a result, they really make an effort to be friends with each other and to be collegial in that way.
Oh, thank you. Liz, if you have anything to add, jump in, or we can talk about a couple of books very quickly and the themes that emerged from those books.
Sure, I'll just jump in since we're having a conversation. I mean, I thought Katie's point about part of what stood out about the relationship is that you have a man and a woman who are very good friends on the court. And maybe that's just another modeling of professional behavior, that's just totally normal. I mean, I think part of the attraction and attention paid to their relationship is probably how much of an odd couple they seemed personality wise, right, which came across in their opinions and personal in their speeches. But I think that's probably right. I'm a tenured professor, so when you have maybe a lifetime, or at least a professional lifetime, of living with the same people, you have some friends and colleagues who you get along with quite well interpersonally, even if you think that they've never said anything that was right. So I think that's a convincing account. Yeah.
Oh, thank you. Well, HCDLA in 2015 did a CLE on this book, on the legacy of Ruth Bader Ginsburg. The editor was a fellow named Scott Dodson, who came and spoke and put together what was touted as the first legacy book that went into serious detail. I'd be interested in y'all's comments on it, but the great essay that he put at the end really ended up with the thesis that Ginsburg was a great manager of conflict. It emphasized what Katie had said earlier about equality and the emphasis she made to the end on the issues of equality and liberty. Both that book and this one, which was much earlier in 2001, which was a book event my law firm hosted. In both of these two books, this one is called Supreme Court Decisions and Women's Rights. It heavily focuses on Ginsburg work and decisions, but it begins with the key work that Justice Ginsburg did for the ACLU Women's Rights Project, as well as at the court. And both these books had identical themes, albeit many years apart. And it was that Ruth Bader Ginsburg's contribution to the world was varied. Her techniques in winning victories and her work for the ACLU and what she did in court for gender equality sometimes overshadowed her other triumphs in federalism and in the other areas of expertise for which she is so well known. And so her key work for the ACLU, how she revolutionized use of strategic litigation, her brilliant ability to manage conflict, including what could be potential conflict with a lifetime partner, in essence, and are both themes that this person who believes so deeply in equality was viewed in both books as neither an originalist or a purposivist. She was able to manage the conflict between the kinds of justices are so extreme and was able to bring those issues together. The last thing that emerged from these books, and from slight personal experience, only because for 6 months I had a very short set of letters correspondence with her, is that her goodness and her kindness in encouraging women, in treating them as if they were colleagues when she's a Supreme Court justice. And when women lawyers wrote to her, she replied. And I have this short series of letters that are written unlike any other correspondence I've ever had, where we invited her, I invited her to come talk about this book because she'd written the foreword to it, and she had to decline. And then I invited her to the opera because I scored some really good tickets. And so we ended up in this correspondence where she talked about her health, what prevented her from coming, what she thought about opera and the law. And it's reflected, and it's not unique. And I wanted to ask you about all the things I've just said, particularly this last point. I'm told that thousands and thousands of young women or older women wrote to her and all got the same decent, respectful, kind, extraordinary replies. It was the ordinary for her. Reactions?
Just picking up on your last point, I think that one thing that really stood out for me from just even my first interview with her was just she really was this incredibly gracious, kind person who cared about people on a personal level, you know, and she extended that really to everyone. And I think one of my favorite memories from my clerkship year was at the times when I was able to, in general, when I was able to bring family members and friends to watch arguments, and she was always more than happy for us to bring our family in to meet with her and speak with her. And one of my favorite times that I got to do that was I got to introduce my grandmother to her, who is the same age and grew up in somewhat similar, you know, they grew up in the same generation, had some shared kind of experiences of both their husbands fighting in the Korean War and or being in the military during the war, and but then also these very different lives. So it was for me as a woman of, you know, 2 generations later to witness that kind of meeting and think about everything that meant and everything that Justice Ginsburg meant to women. That was really meaningful. But then on a personal level, it was also just the time that she took to stand and talk to my grandmother about, you know, their lives and this, you know, this person she was going to meet one time. And she extended that to everybody that we brought in to meet, and she wanted to know our families, and she extended then that care to people who wrote to her too, that, you know, I think that's something we really learned since she passed that I hadn't really realized was how much time she spent when she was already a very busy person on, you know, and if she wrote something to you, she probably wrote it and rewrote it 3 to 5 times, you know, a generous estimate, because that was the care that she put into anything that she, you know, put on paper. And she gave that care to everybody. So yeah, that was a really special aspect of who she was.
Oh, that's so meaningful. I was surprised when she passed, how it felt like I'd lost a mother figure. And I think having talked to other women, and I'm sure other lawyers, I went to law school in the 70s, and her work ongoing through now 40 years, more than 40 years later after I graduated, is such a body of work. I never met her, but felt I knew her. And I'm wondering, Elizabeth, from a from your perspective, any comments or reactions as a professor now in the real world? So,
yeah, I feel like her work, she was sort of a symbol to many people, right? Most of us didn't know her personally, but we knew her through her work, through her biography. And I think they're all very tightly related. I think she sent the signal that women were appropriately in the wage labor force, in the professional sectors, in politics. And her basic message, you know, she was a mother as well as a lawyer, and then a judge and a justice and a law professor, right? And she represented fathers as well. And I think she destabilized some of those categories, right? That being a father doesn't mean being an absent wage laborer, that being a mother doesn't need to define you professionally, that you can be a justice rather than a mother justice. You know, so in a way, though, I think there are downsides. She came from a generation, and probably the generation below her, at least in law professors who are women, had to work so hard. They will tell you proudly about how they had a baby and 10 days later were teaching. That's a tragedy. That's not something to be proud of. Yes, you got through it, but it's not something we should be celebrating. It's something we should be mourning that people had to do that. So, and I think part of the problem is that people like Justice Ginsburg taught a generation of women and men that they could have it all. They could be engaged fathers and also succeed in law firms. She told women the same, but not at real cost. And right now, during the pandemic, I think we're seeing people just be crushed by the idea that we can have it all without being supported at all. We can't do it all. Maybe we could have it all, but we need help from one another. And I think that's sort of missing in the, not necessarily the vision of the feminists of the 1970s, but the achievements of that movement and the symbol that they hold today.
That's so meaningful that I think it's probably time to let the rest of the questioners be vetted and curated by Adam. And so, Adam, if you can jump back in, or Harold, if you can get Adam back in, why don't we turn it over to Adam for additional questions curated from the audience.
Yeah, and like Barbara said at the beginning, we have a couple that are, people reached out to us ahead of time and wanted to give them an opportunity to speak. And so I think the first person we have is Justice Landau. But before we let her ask her question, just want to remind everyone that if you have questions, please put them in the chat. I don't know if we'll be able to get to all of them, but it would be, if you have something you want to ask the panelists, go ahead and put them in. We'll try to get to as many as we can. So, Harold, can you let Justice Landau ask her question?
Can you hear me?
Yes, we can hear it.
Yes.
Okay, sorry. Thank you so much for this wonderful, wonderful panel and presentation, HCDLA. I have a question for the panelists. I was wondering if you had kind of a favorite Justice Ginsburg dissent, either what she said or how she said it that really resonated with you.
For me, I would say her dissent, well, I suppose partial concurrence in NFIB v. Sebelius on the issue of Medicaid expansion was extremely powerful because she really concisely explained why it is that it can't be that the spending power limits Congress's ability to give so much money to the state that it becomes a gun to the head, right? That you just give so much money. How could you resist that much money? This is the precise opposite of what we've done everywhere else, right? The Supreme Court doesn't care that you're too poor to get an abortion or that the state is offering you lots of money to have a baby as opposed to terminate your pregnancy. but pots of money under Medicaid. So I thought that was a great and an illuminating opinion, and it also really showcased the harms of rejecting Medicaid expansion, which we've seen play out in real time, luckily, with most states having decided to expand at this point, though not Texas.
I'll say I can say what I think the justice's one of her favorite dissents was that she wrote. She had a handful of cases that I think she was especially proud of and spoke of often. One of them being the VMI opinion, which obviously was not a dissent. The other being the dissent in the what ended up leading to the Lilly Ledbetter Act. And that case, I think she felt especially proud of because she felt like I said something and Congress listened and they fixed it. And that was something that she was very proud of, and her clerks a few years before I clerked were able to get her a signed copy of the Lilly Ledbetter Act that I believe President Obama signed for her, that she had hanging very prominently in her chambers and was very proud of.
Okay, well, thank you. Barbara, do you have anything you'd like to add, or anything you want to?
No, I'm really enjoying the give and take. It's fabulous. The dissents and the footnotes, I will say, I'd throw in. I'm especially interested. Both of you all have clerked at very high levels, and the efforts that I'd like you both to comment on her footnotes, which are each one a Cardozo brief sometimes. So if you don't mind, now that you've got a question about dissents, I'd love to hear about the footnotes and how they seem in some of the cases so important. Too nerdy? Too nerdy.
I feel like that might be too nerdy for me, and I footnote for a living, basically. Do you have favorite footnotes? Do you have footnotes that particularly stand out to you as
the ones in Hobby Lobby? The ones in Hobby Lobby marshaled the evidence that I felt the majority felt they had to, that somebody wrote their majority opinion to try inadequately to answer the evidence marshaled just the way Cardozo taught that policy analysis should be important. So and I'm not a Supreme Court expert like y'all are. I just know what I love, and the writing, the footnotes in Hobby Lobby. I mean, you guys probably don't read those in bed at night, but man, those are good footnotes.
Okay, well, thank you, Justice Landau, and thank you, Barbara, for, I never really thought I had a favorite footnote, so that's probably why you were a better lawyer than I'll ever be. For our next person, the next question is from Angela Brown.
Hi, good afternoon.
Hi.
Thank you for this. This is wonderful remembrance of Justice Ginsburg. Justice Ginsburg was nominated in 1993, which was when I was a junior in college, and my first voting. And so it was an inspiring time. I find myself now in the position where I'm the mentor and I am the person setting the culture for my office. And my question to you is, you talked a little bit about her legacy and having it all, and maybe that's not what we can do now, but having worked with Justice Ginsburg, can you tell us what she said to you that inspired you to keep going, to keep the passion alive?
So I will say Justice Ginsburg was a woman of carefully chosen words and not too many of them. And so she was not sometimes you have mentors and people you work for who, are giving you extended talks with a lot of direct advice or they speak in aphorisms or what have you. Justice Ginsburg was not that way. She really led by example, I think. And to Liz's point, I don't necessarily think her example was always something that a woman of my generation would necessarily want to emulate in terms of like sustainability of, the sacrifices that the justice made are incredibly admirable, but I agree, are not ones that should always have to be made. At the same time, she also, I think, was a person who, especially by the time I clerked for her, was, complete. The job is a large part of what kept her going, and was a huge motivating force for her, especially having lost her husband. And, this was the center point of her life. But I think what she really taught us, again, by example, was just that example of like grinding, hard work, methodical kind of effort. We as clerks would spend hours standing next to her at her desk, going line by line through a draft. And I think to some extent that was teaching of how to write. And on another hand, I think it often very much felt in terms of, we're talking about creating a culture of work and all of that she really valued us as being her partners in the drafting process and in the work, and we were all part of this common enterprise together, and that she really valued us being there alongside her and working through things. But yeah, we just really saw as clerks the methodical nature of how she worked. She would edit something until, even like a speech she would give, not even an opinion, she would edit it multiple times in her own chambers over the weeks before, and then she'd still be editing it in the car on her way to give the speech, and probably editing it as she walked up to the podium. And to some extent, she was just that kind of person, but that attention to detail and that devotion to everything she did, and that she always kept this very kind of level-headed approach to everything. Everything was important, and she devoted the time to it, but she also didn't kind of get overly worked up or wrapped up in any one thing. It was kind of, all of the work was important, but you just kind of kept your head down and did it, and then you moved on to the next thing. And so I think that's really what I took from her.
May I ask, as far as how she interacted with you clerks, did she ask you to help her? How did she direct you? For example, when I say some things were Brandeis briefs or whatever I called them, when did she direct you, for example, on the specifics? If she said, I want to marshal some evidence, go out, search the briefing and the amicus. Well, how did she do that? If you don't mind, there's several questions people are asking about. Tell us a little bit more about the work relationship.
Certainly. So the work relationship, again, she was more of an old school kind of justice in the way that she operated, in terms of we didn't kind of, some of the justices or judges I clerked for, they'd pop into your office and talk to you about an issue. Our relationship with her was often a little more formal, where we were writing memos, asking her questions. At the same time, her door was always open if we felt like something was important to kind of actually actively walk in and ask her about. But, on any given case, the general framework was we would write a bench memo for her. And that was kind of self-initiate. We chose which cases we wanted to work on as clerks, and she let us allocate that among chambers ourselves, and kind of gave us a lot of leeway to just, we were professionals that could figure that out amongst the five of us, kind of allocating the workload. But then from there, once you had a bench memo and she had started reading in on the briefs, and she would start that all very early, she would come to you with specific questions. If she had, there are some cases where she'd say, okay, I'm good on this. Like, I don't really need much more from you. You gave me what I need. Then there are other times where she would say, and she would usually buzz you in your office, and call you and ask you this question while it was top of mind for her. And just say, Katie, I need you to give me a list of these things that happened in this case so I have it for argument, or I need you to run down this one issue for me, and I have this question that I don't understand, and I need you to help me understand it. And so there was that back and forth, and then there was even more of it if there was to be an opinion of some kind that she was writing. And then the drafting process was its a whole other beast, kind of what I was describing in terms of a lot of back and forth on drafts and editing and back and forth. So that was kind of the general process of things.
Right, and Katie, I'm gonna want to ask. We've gotten a lot of questions about her love of opera, and a couple people have wanted to know if she tried to share that with her clerks or get them to appreciate it. Did you ever get any pressure to go to the opera? Or?
Yes, she did. Well, she very kindly took all of us and our significant others to an opera performance together. And when we had a meeting kind of the week, or for several weeks before, every time we had a meeting, at some point towards the end, she would say, and we're going to the opera soon, and here's what I think we saw La Traviata, and she would explain the plot and explain the significance of the opera to us, because she wanted us to understand it when we actually went and saw it. But, it wasn't kind of a, she expected us to become experts in opera at any point in the year, but it was something very, special that she did share with us. And one of my favorite memories, because seeing her at the opera, especially afterwards, we went to this after party with the performers, and when they walked into the room, she just lit up and ran and gave, the giant opera singer this big bear hug, and like it was, one of the more animated times that I ever saw her, and she truly just loved it and enjoyed it so much. So it was fun to be a part of.
What did you catch the opera bug? Have you gone to the opera since then?
No, I will say actually, when I clerked for Judge Brinkema in my first clerkship, she was also an opera fan, and I have tried, and it just hasn't caught for me.
That's okay. I think that's okay. So I think our next question is from Nicholas Spencer.
Hi, gang. I had a quick question about Justice Ginsburg's, the way in which she approached her job. I feel like her particular genius is that she was able to look at problems from more than one side at the same time. It's why she was able to use the cases for advocating men's rights in order to advance the cause of gender equality. And I'm specifically thinking of her use of like metaphors in like the Shelby County case, where she talks about the throwing away your umbrella in a rainstorm, that sort of thing. So I'm wondering if you guys can talk about what you think about that, how she approached that particular part of her task, and if Catherine had any wonderful metaphors that didn't quite make the final cut that she wants to share with us today.
Liz, it might be better for you to start on this one, but I do not have anything that she left on the cutting floor. I will say we as clerks would often try to emulate her voice or insert things in drafts that we thought, oh, this is really great and clever, and she might like this, and it almost never made it. So she had her very own distinctive approach.
Yeah, I think it's a great question. I mean, I think you saw it in particular actually at oral argument, that she was able to, in her slow and wry style, to sort of come in on both sides and really cut to the heart of the case, or bring up hypotheticals, as you said, that proved exceptionally difficult for litigants to deal with. And regardless, right, she's flipping around and looking. And I've seen people criticize her writing in the past for the sort of her methodology, right? That she tended to go through and say, well, this point is wrong, and this point is also wrong, and this point is also wrong, when she's dissenting, or in building out, a majority opinion, going through each part and then tackling each part of the dissent of any dissent in the opinion. But I think it's very valuable, and I think she often proved quite adept at doing what you say, presenting a phrase that made it clear how silly the other side was, or how wrong. And again, I think about the Medicaid case, because I'm a health law person. She pointed out, right, it cannot be the case that this is unconstitutional, because all this would mean is if tomorrow Congress just repealed Medicaid and immediately enacted the whole thing with the expansion, then it's constitutional. That makes no sense at all. And she has nice lines in there too, where Chief Justice Roberts is drawing a distinction between a 6-year-old and a 7-year-old who are covered. And she said, it cannot be that your seventh birthday is constitutionally significant. And so just really powerful lines that illuminate sort of, or undermine the majority argument. Yeah.
I will also say that was kind of just the way that she spoke in general. Again, her words were very carefully chosen, but you know, my group of clerks, we still have some vivid memories of very vivid terms of phrase that she used to tell us exactly why she didn't like, you know, a way we had written something in a draft. And so that just that imagery and the way that she, that was kind of the way she spoke all the time. And so that's very truly reflected in her writing, I think.
Great. Thank you. Thank you for that. Thank you for the question. We've got a few more minutes here, but I wanted to maybe ask a kind of a closing question of both of you, and see if you had a favorite, you know, opinion, or an opinion that you thought maybe best kind of defined, you know, her legacy in your mind, at least, you know, what you associate most with Justice Ginsburg. All right, well, I guess that's puts you on the spot there.
It's hard for me to narrow down. I think there's just such a wealth that it's difficult for me to choose.
Adam, we have one question that came in at the last minute from Judge Kennedy. I don't know if you can see it.
Nope.
It for you.
Judge
He asked, did you go to the court and stand on the steps with other clerks? What percentage of her clerks were male versus female?
I did attend the services for the justice, and it was a really meaningful, profound experience to be a part of. And what was especially special was, you know, a lot of people I think saw the part where we stood kind of on the plaza and welcomed the justice as she was going to come lie and repose at the court. But then all of the clerks who came into town, which I think about 120 of her 160 total, were able to come and spent the next 48 hours straight standing vigil by her casket for 20-minute stints. And so she was, you know, she was watched over by her clerks literally every minute of the 48 hours that she was at the court. And I think it was really a testament to the loyalty she inspired. And I do not know actually the breakdown of, I'm sure someone out there has run these statistics. I will say my year, we had a chamber of 5 clerks and 3 of us were female and 2 were male, but I'm not sure over the years what her breakdown has been.
Thank you. The other question we had was, did she tend to keep earlier drafts of speeches, notes, opinions, anything like that, or you know, were her did you kind of throw out some of that stuff once it was done?
I think a lot of that would be in files for the cases. I wasn't allowed to take anything like that with me when I left the court, but one day I'm sure there will be, you know, all of her old case files will be released at some point a long time from now, I'm sure, and everyone can see exactly how she edited things, but a lot of them exist somewhere, I am sure.
Well, thank you.
I got one last one. Did she like the RBG, the movie?
Yeah. She loved the whole, again, like Liz said earlier, the notorious RBG kind of character was really not her as a person, but she kind of loved all of that. Yeah, she really enjoyed it.
Well, thank you so much for joining us today, and Adam, thanks for bringing in Liz and Kate, and Barbara for being the driving force between having this today. And I can see from the comments that people really appreciated the opportunity to look back on the great work of Justice Ginsburg. Please don't forget, join us on the 29th. We're planning something big, fingers crossed, kind of like we did after the 18 for hopefully celebrating great results for Democrats in Texas, Harris County as well. And keep tuned for that. If you haven't already registered, please do. It's easy peasy. Just go to hcdla.com. Barbara, any closing thoughts before we bring it out?
Just a big thank you to all of TDLA and everybody here. And I think if I learned one great theme from this, not just consistent, but greater, is that this is a critical thinker. And I think that's where the future of everyone is. I think we'll be thinking more about critical thinking.
Will that be different?
Yeah.
All right. Thank you all very much. Thank you, Harold, for doing a great job on technical stuff. We'll see you next week in early November. Fingers crossed. Thank you again. Have a great day, everybody.